Hello, my name is Natalie Villegas, and I'll be talking about the court case that was decided on June 24th, 2022, called Dobbs versus Jackson Women's Health Organization. The petitioner of this case was Thomas E. Dobbs, State Health Officer of the Mississippi Department of Health. He stated that abortion isn't constitutional, and it wasn't stated in the Constitution. The respondent, who was Jackson's Women's Health Organization, argued that banning abortion after 15 weeks goes against the constitutional right to abortion. According to Yale Medicine, abortion is the termination of a pregnancy before the fetus can survive outside the uterus, or before 28 weeks. It can occur spontaneously, known as miscarriage, or it can be induced intentionally through medical or surgical procedures. Dobbs versus Jackson refers to the intentional abortion. The facts of the case are that in 2018, Mississippi passed a law called the Gestational Age Act, which prohibits all abortions with little exceptions after 15 weeks gestational age. However, the state hadn't provided any solid evidence that a fetus could be viable at 15 weeks, and Supreme Court precedent prohibits states from banning abortions prior to viability. The question asked before the court was, is Mississippi's law banning nearly all abortions after 15 weeks gestational age unconstitutional? In conclusion, the court decided that the Constitution does not mention abortion, and the right isn't deeply rooted in nation's history nor an essential component of ordered liberty. The court decided to eliminate the federal constitutional right to abortion by overturning Roe v. Wade and Planned Parenthood v. Casey. The legacy of the decision in regard to the Constitution brought back up the issue of abortion regulation to the elected branches and the elimination of federal constitutional right to abortion. This decision doesn't directly ban abortion, but it allows state regulation. In addition, in court, people can no longer argue that abortion is a federal constitutional right.